So the Checkoff case, we really have filed two cases for you. One is in Montana, and it's a First Amendment challenge. And another is in the District of Columbia before the DC courts, and it's what's known as an Administrative Procedures Act challenge, or APA challenge, the most kind of common regulatory challenges that are out there. But I think it's best to think about these cases as actually having three different components. The first is what a really big success, and one that we're very proud of and very proud to have been working with Bill and the RKF staff on, that has proven that the state beef councils have been acting unconstitutionally for decades. The second part of that case is less of a win, and we're still trying to figure out what to do about that, and it asks the question, kind of, now that we know the state councils were acting unconstitutionally, what do they have to do to bring themselves into line with the Constitution? And I think that the Ninth Circuit has gotten some stuff wrong there about what is required by the First Amendment and how far the state councils and the government can stretch the First Amendment to continue to maintain the checkoff programs. The third, which I'll discuss at the very end, interrelates with both of these questions because it goes to how the government tried to solve the constitutional problem. And it says, independent of the Constitution, did the government properly abide by its rules and regulations for how it tried to solve and fix the checkoff program? And as we'll discuss, while these are really two separate legal issues, they begin to intersect both legally and at a policy level. And so looking forward, that's one of the things that we're really interested in terms of thinking about how we can help RKF continue to press some of the policy issues, even as these court challenges begin to wind down. So next slide, please. To understand what I've been talking about in terms of the Constitution, it's important to kind of get two sets of ground rules in place so that we all are having the same kind of conversation. The first is that as a general matter, the Supreme Court held that the checkoffs fail First Amendment scrutiny. So essentially, if the First Amendment applies to the checkoff programs, then they cannot stand. That's because what the court says, the checkoffs amount to what are known as compelled subsidies of speech, which the court has said are the equivalent of compelled speech. In other words, just like the government can't force you to say anything, it can't force you to pay for someone else to say something on your behalf. That's the equivalent of forcing you to say something. Money is part of speech, and if you're funding someone else's speech and you disagree with it, that's the equivalent of making you say something that you don't like. And what the court said is this is such a clear and established principle. It doesn't matter what level of scrutiny the courts apply to the checkoffs, or whether they're commercial speech or political speech. We don't need to get into that kind of debate. The checkoffs so clearly are inconsistent with that rule that they are unconstitutional if the First Amendment applies. And that was, in this case, United Foods, and I consider the mushroom checkoff program. And the case that you all are probably most familiar with came next, which is the Johans case, which considered the beef checkoff program. And this is the first of a line of cases that are known as the government speech cases. So historically, the court has never had language to talk about what happens when the government engages in speech. When the government, prints those posters that say, I'm Uncle Sam and I want you to join the army. What if you're a pacifist and you would disagree with that? Can you object to those posters? And for a long time, what it just said was, well, we don't need to wrestle with that because most of the way the government acts is not really about producing speech, but it's producing something else where speech is just an ancillary part of that. So using the Uncle Sam if it produces some posters along the way to help it in that process, we're not going to worry about that. We don't really think the point of those expenditures is speech. And so we're not going to worry too much about that. But when the checkoffs came along, what the court recognized is that the only thing the checkoffs do is fund speech. They have no purpose except to fund expressions. That's the entire point of the exactions. And so it needed a new language to talk about this. And it developed what is known as the government speech carve out from the First Amendment. And so what it said was that when the government controls the speech, so particularly looking at the expenditures of the Beef Board and Beef Committee in Johans, when it controls the speech, we're going to say that is in fact the government speaking. And we're going to say the First Amendment applies, or excuse me, does not apply. And so everything I just told you about United Foods, about how we don't need to worry about the scrutiny, it's so clearly unconstitutional, all of that gets thrown out the window because the First Amendment just doesn't reach expressions by the government. And there's some sense to this, right? You know, the government speaks in lots of ways. You can imagine when Congress passes a bill that has lots of words in it, and it's essentially a form of speech. If a person could say, well, that's violating my First Amendment rights because I don't agree with what the government's saying there, that would be pretty problematic. And so the court has tried to carve out this exception to the First Amendment. It has done so in a way that has been exceptionally criticized. The court itself, particularly Justice Alito, but a number of other justices, including Justice Breyer, have said the court's reasoning here doesn't make a lot of sense, that it's put too many things in the government speech basket, that it hasn't defined the test well enough. There's a whole bunch of criticism here, but you kind of get the underlying motive, and with that underlying motive, the checkoffs got caught up. And next slide, please. But what we started working on with you all is this question, well, the court focused on the Beef Board and Beef Committee, but there's this whole other part of the Checkoff program, the state beef councils, that no one's really paid any attention to. And it turns out the state beef councils, as you all know, but most people who are unfamiliar with this world don't know, get half the money. They're getting a decent amount of the revenue that you all are paying. And the court's never really considered whether that's government speech or not. What is the form of expression there? And so we thought one of the ways in which to increase ranchers' leverage over the program was to try to take on those expenditures, to say that even if you can't get rid of the Beef Board and Beef Committee's expenditures, it shouldn't be that all this money is treated the same. And we're going to need to analyze the money separately and see what's going on with the state councils, because that felt a little out of control. And indeed, when we all started this work years upon years ago, one of the things that certainly caught public justice's eye, and I knew was very problematic for RCAF, was that the Montana Council was spending money to fund Wendy's advertisements. It was saying, this is USA beef, and we all know that that term is misleading to begin with, and why in heaven's name are domestic ranchers paying for Wendy's misleading representations about it using USA beef. So next slide, please. Sorry, can you go to the next slide, please? Thank you. So the first part of this case was a smashing success, and quite frankly, more so than I anticipated it was going to be when we started this, that the court basically agreed with us. It said that these state councils need to have equivalent regulations as the Beef Board and Beef Committee, and they don't, or at least did not. And we'll get to that tense clarification in a second. But that the councils were taking the money and they were using that money for their own determinations. They were not subject to the government control, and therefore this exception to the First Amendment did not apply. And we were back in the United Foods world. We were back to where your compelled funding of these state councils was just plainly and clearly a First Amendment violation that needed to be stopped. And the idea there was that the ranchers who then were paying could then have power over the councils to say, I'm not going to let you take my money unless I have more of a voice. One of the other exceptions to compelled subsidies is if you agree to them, they're no longer compelled, they're voluntary. And so you could give your money voluntarily to the councils and thereby have more control over them. And that was part of the goal here. And essentially what the courts initially said was, That's just true. You should have that right for years upon years. And literally since the Checkoff began, these councils have been allowed to misadminister these funds. They are not subject to federal control, and therefore every one of their expenditures is unconstitutional. Next slide, please. And the other thing that came out as this case was developing, as I said, we initially focused on Montana, and then we realized that there's nothing special about the Montana Beef Council, that the Montana Council is a privately incorporated entity, and the government's disinterest in engaging with it and uninterest in regulating how your money was being spent was true across the nation. And we expanded the case to include these 13 other councils, 14 total, that are all, and what's unifying among them is that they're all private entities, they're privately incorporated. Some councils in some states are created by the state government, and there's a separate question about how, given our federalist system, that type of regulation intersects with the federal government's obligation to control the checkoff. And so for purposes of these cases, we kind of left that to the side and just focused on what was the councils that we knew were operating unconstitutional. And so the case expanded to these other councils crossing the nation. And throughout all these cases, the government and then the councils themselves argued that RKF didn't have a sufficient interest in challenging these councils' expenditures. We've repeatedly beat that back. Every court, even when we've lost other issues, has found that RKF has a significant both financial interest itself and on behalf of you all to ensure that these councils are operating constitutionally. And so we received the right to try to prevent these councils from spending the money inappropriately. Next slide, please. So unfortunately, we're up against a big conglomerate in the state councils and the NCBA and the entities who they serve, and also against USDA, who has consistently worked with NCBA and the Federation of State Beef Councils and others to try to defend this program. And so what happened was that rather than kind of let us win and kind of go home with our victory, USDA began to try to modify the program. And it specifically began to try to modify the program through these things called memoranda of understanding. They're just contracts that were entered in between USDA and the state councils in all the states that we were challenging and then some. And what these MOUs tried to do was alter the relationship between the government and the state councils to say that the state councils were no longer allowed to operate independently, but that the government was going to have more direct involvement in how they spent the checkoff funds. And I kind of tick off for you through this slide all the different ways in which the government has tried to assert control. So it gets notices of the meetings now that never happened before. So when we were originally litigating this case, for instance, there's no way to figure out when the Montana Council met. They have to submit annual plans. All the councils have to submit annual plans to USDA. USDA never previously reviewed those. They have to make their books available when USDA wants. They have to provide an annual report, and possibly most importantly, for the actual activities that are carried out by the councils or people working directly on their behalf. All of that has to be approved by USDA. So now USDA actually hired 2 new people to carry out this new role. All the kind of ads and pamphlets and PowerPoints and things like that that you see produced on behalf of the councils actually go to USDA, and USDA needs to sign off. And USDA, if the council fails to comply with any of this, USDA can quote unquote decertify the council, remove its ability to receive funds. So the response was that this solved the problem. Maybe the government wasn't properly administering the program before, but now this solved the problem. The government also tried to argue this was entirely unnecessary, that we were just making a mountain out of a molehill, but at the very least, this solved the problem. Next slide, please. So the first part to recognize here is that we were able to prove that this was not a mountain out of a molehill. that absent these agreements, the courts have repeatedly held that the councils cannot operate constitutionally. In other words, if the MOUs were ever to get repealed or the councils were trying to back out of them, or the government were trying to change them in a meaningful way, the state councils would revert to being unconstitutional. The only way in which they can operate is with these MOUs. That's the first hold. So the kind of initial argument, these MOUs are unnecessary, the Constitution doesn't reach the council's expenditures otherwise, because it's government speech, fails. The councils are going to be unconstitutional and their expenditures are not going to be allowed but for these MOUs. So I think that's another significant win here in establishing and concretizing the fact that these councils have been for decades misusing these funds. This has been a misadministered and corruptly administered program for over 30 years now. Where things get a little bit more disappointing is in the next slide. And so next slide, please. The first thing that the courts held was that the MOUs themselves, in terms of the rules and regulations they set up over most of the expenditures, are sufficient. So that because the government's reviewing most of the council's expenditures, that review is sufficient. When it signs off on the specific statements that the councils are going to make, its ability to kind of sit in on meetings, its ability to review annual plans, that collective set of review is sufficient to turn what was private speech into government speech, similar to what was before the Beef Board and Beef Committee. And so the court said they weren't going to require more than the MOUs. And we raised several arguments about the MOUs themselves. We had specific concerns about the nature of the government's review of those expenditures. You know, having actually looked at the documents, it doesn't feel like the government actually does that much when it reviews the expenditures, but the court said that if the government has the ability to do more, even if it doesn't exercise that ability, it's choosing not to exercise that ability. And so we're not going to say that it needs to do more as a matter of course. We also raised an argument that with the Beef Board and Beef Committee and really every other checkoff program in the country, the government actually has to appoint the people who are making the expenditures. So you have some confidence that those people are actually expressing the government's views. And if the government wants to remove them, it can remove them. It doesn't like the expressions that's creating. And the court said, yeah, that's true, but like this is close enough, essentially, that if the government is doing all this other form of review, we're not going to require the government to actually appoint the people. That's never been a singularly just positive factor. And so we are going to allow the state councils to continue to operate with this kind of supervision. We thought we had a really nice hook, though, to push back somewhat, because it turns out there's a pretty large loophole in the MOU. So next slide, please. The loophole in the MOUs is that while I said the government needs to review all the expenditures of the state councils and those who work directly on their behalf, it actually allows the state councils to turn money over to other entities who then can use it how they choose. So if the state councils say, we want to produce this ad, that gets reviewed by the government. If they go out and hire an advertising agency to produce an ad on their behalf, that gets reviewed by the government. But if they say we want to make a donation to this third party and we want to support their advertisement, for reasons that are entirely unclear, that doesn't get reviewed by the government. And in fact, large amounts of money go to third parties for this in this way. In particular, the state councils transfer money to USMEF, the U.S. Meat Export Federation, and NCBA to use the money at those councils, at those entities' discretion. And that doesn't fall within the MOUs. And so one of the issues we really highlighted and brought up to the Ninth Circuit, the Court of Appeals, was this loophole. Next slide, please. And what the Ninth Circuit held in a fairly concerning decision is that if all the rest of the expenditures were government speech, they weren't going to get involved with this loophole. They have this line in a variety of their cases that the Ninth Circuit's not going to micromanage the government. And so if the government gets close enough in a variety of places, the Ninth Circuit's not going to say that it has to do more, which doesn't make a lot of sense, right? This is a constitutional rule, and the government's not following the Constitution. There's no kind of constitutional close enough principle. Either you are or you aren't following the Constitution. And the Ninth Circuit pointed to a host of things that the government kind of does related to this. It can review annual plans or attend meetings, but because the money is being turned over to third parties, neither those plans nor those meetings say anything about what those third parties are going to do. And the Ninth Circuit also focused on the fact that if the government doesn't like the speech after the fact, it could somehow discipline the councils. It's a little bit unclear that's actually true. That when the government could quote unquote decertify the councils is, I think, more limited than the Ninth Circuit. But regardless, typically once speech is issued, once you are being forced to pay someone for someone else's speech, that's the equivalent of you being forced to speak, and that's a constitutional violation in itself. It is saying, it's not like you can be forced to speak or you can be forced to fund someone else's speech, and if they apologize to you afterwards, that cures the constitutional violation. Once that forced speech happens, we've got a problem. And nonetheless, the Ninth Circuit focused on this kind of post hoc rectification to say, we're not going to touch this. And this is part of a long line of cases in which the Ninth Circuit has been highly reluctant to, and most courts have been highly reluctant to kind of get in on the nuances of this. They'll kind of look at it at a high level. They don't really want to kind of get into the specifics of what kind of controls need to be there. For some reason, they feel uncomfortable with that. They feel like there's just enough wiggle room, and the court hasn't laid down clear rules. And so we are now at this place in which the MOUs are required. And in fact, the government needs to review every single statement that's actually issued by the councils, but they can give some of this money to third parties, and those third parties can kind of do what they want with it. So we're this odd nether region between the two worlds, and that's where the Ninth Circuit has left things. And I will say the Ninth Circuit panel had it was a very moderate panel. Typically, when you think about a court being likely to reverse itself, known as going en banc, you are looking for a couple of things, either a dissent or for the panel to be really kind of weighted towards one side of the court where you think the other side of the court might be inclined to say, this just isn't aligning with our worldview. The panel here was real kind of middle of the road to slightly conservative members of the Ninth Circuit. It did not kind of feel like it was weighted towards one point of view in particular. And there was no dissent by any of these judges. So it feels like we're kind of stuck with this Ninth Circuit view, although as we'll talk about at the very end, there is, of course, yet another layer of review of the Supreme Court. Next slide, please. Nonetheless, while all this has been going on, we kind of came up with another way to try to advance this interest. So, the MOUs are documents that regulate how the Checkoff program operates. And according to those other decisions that we won, the courts were very clear the Checkoff program could not operate independent of these MOUs. Typically, that's what's known as a regulation. And in our system, our regulation has to go through certain procedures. And when the MOUs were issued, the government followed none of those procedures. So you probably have heard Bill and others talk about commenting on regulations, waiting for final rules, getting notices of proposed rules, having the government reconsider rules based on comments. None of that happened with the MOUs. The MOUs were just issued. And nothing, the government just said, we can do this. And however, the only way this program functions is through the MOUs. Those are typically what are known as kind of legislative regulations or legislative rules. Under a variety of precedent, they require notice and comment, and USA just didn't do that. So we sued over that. We said that if you're going to issue these MOUs, you need to consider what people want to see about the relationship with the state beef councils. You need to consider whether you need to, in fact, have more regulation. And therefore, we are entitled for you to repeal those MOUs and allow RCAF and other ranchers and other groups to comment on what we want to see in those MOUs. That case is in the very early stages. What happened was the government again said RCAF had no interest in this, it lacked standing, and it also said we should have brought this claim at the same time we filed the case in Montana, even though the MOUs didn't exist at that time. And so we have fought that. We filed papers with the court in DC. Those papers were all filed back in January, and we're now waiting for a decision. Those decisions can take an exceptional amount of time. I have no way of knowing when they're coming down, but just by way of reference, I've been waiting on another decision from the DC court for over 2 years now. So, I just have no way to tell you for certain, but it can be a very long time. The good news is if we were to win this, two potential things were going to happen. Almost certainly, RCAF and you all and allied groups would get to comment on the MOUs and get to demand certain forms of reform to the MOUs and the state beef councils, which the USDA would have to consider. In other words, this would open up another potential for you to get political leverage over the state beef councils and over USDA to try to get your voice heard. That's almost 100% guaranteed if we win. The more complicated part is what happens to the MOUs while that's happening. In our ideal world, what happens is the MOUs get revoked. And per my earlier slides, if the MOUs get revoked, the state beef councils can't be getting your money. And the state beef councils only operate constitutionally if the MOUs are in place. So in our ideal world, what would happen is while the MOUs are being reconsidered, there would be a stay on the state councils getting your money unless you voluntarily giving you more control over the state councils. I will admit to you that is much, much less likely. Courts are unlikely to disrupt systems if they think there's a chance that USDA could come up with a program that would essentially lead to the same result. So even if they were to modify the MOUs, the court believes that USDA was likely to reissue them in some form after notice and comment, it's likely to let them stay in place while that notice and comment procedure is going on. But that's something that we will be fighting about later on, and it's certainly one possibility, one reason we got involved in this suit. As I said, all this is a ways off. We need to get past these initial determinations about standing and whether we procedurally brought the claims at the right time. And then we'd have to brief and argue all this other stuff about, is this in fact a legislative rule? Did it require notice and comment? USDA is disagreeing about that. What's the proper remedy? And then there's always the potential for this to kind of get appealed and get delayed. And so we're talking again, I've been coming to these conventions, I think, since 2017. We're talking, unfortunately, my guess is you will be seeing me for a while still, because this is a multi-year long process that we have begun in the DC courts. At the same time, we have this other option, which we are just beginning to talk about. Bill and I, in fact, are meeting next week about this, about what's the right way to proceed with the Montana case now that the Ninth Circuit has ruled. As you all probably know, the Supreme Court review is not mandatory. It is discretionary, and in fact, the Supreme Court has increasingly taken fewer and fewer cases over the years. So if 10 years ago, the Supreme Court took around 160 cases out of the tens of thousands that are filed every year, now it's only taking about 80 cases. And because this issue is so unique to the agriculture space, there isn't a lot of other cases out there that are disagreeing with the Ninth Circuit about its rules. The Ninth Circuit has some of the most developed law on this, but there aren't a lot of other circuits that have weighed in on this. And so chances before the Supreme Court are admittedly low. But in thinking through what's the right next step, it's certainly something we're considering, and we're discussing this and getting experts to weigh in. That's one of the potential things you could be hearing about in the future. So that's the state of our litigation. The quick summary is, RCAF has now firmly and fully established that for the first 30 some odd years of the Checkoff's life, the state councils have been operating unconstitutionally. The MOUs have now been put in place to try to remedy that, and the Ninth Circuit so far has said that does, which means that going forward, the Ninth Circuit has said the state councils are operating constitutionally so long as those MOUs stay in place. But we have questions about whether those MOUs were lawfully issued and can stay in place. And we have some questions about the Ninth Circuit rule about whether the MOUs are sufficient. And those are the questions we'll be pressing in the courts and hopefully giving you guys some more opportunity to raise those issues with legislators and regulatory bodies as we do so. Next slide, please. So if you want to reach me or have any questions about any of the above, this is all my contact information. I am, as you probably can see from the posters behind me, at home and not at the office. So if you want to talk, I recommend you call my cell, and certainly Bill has all this contact information and we talk pretty regularly. But you know, I'm happy to be available to anyone who has questions about this in the future. And we'll pause now, and I apologize, I don't actually know how long I have in the schedule, but I certainly will take any questions that are out there until Bill and Candace and others rush me off the stage. So
David, you've got about 15 minutes, David. So does anybody have a question while we've got an expert on the screen?
We've got one over here.
Great.
Mr. Muraskin, Von Meyer from South Dakota. Have you examined the two-hat beef consuls and how they fall into the similarities of this suit that you're involved in? You know, the fact that they administer the checkoff and even occupy the same building in their states, to me is kind of selling their organization, and that's speech that I might not want to agree with.
Yeah, so I think that's a great point, Vaughn. And you know, Vaughn, you and I have been on too many panels for you to call me Mr. Muraskin. I think it's Dave is more than fine. But I think that's a great point. So, you know, for those of you who aren't familiar with what Vaughn's talking about, numbers of the states have the beef council is actually run by yet another entity, typically some affiliate of NCBA. And it's housed within the affiliate's offices. They are able to share space in a variety of ways. They're able to share resources. So two separate things are true. For those two-hat states where the councils are fully under an affiliate of NCBA, they're already part of our suit. So that's Kansas, North Carolina. You know, if the affiliate is a private entity, as it almost has to be, they're already part of our suit. And so that was part of why we expanded the case to include them, is they are similarly situated private entities. The other part of this, and I think what Vaughn's getting at, is, how do we deal with the fact that effectively, even if they are acting constitutionally and that the government is supervising their speech, that money is in some ways going to another private entity with which you would disagree. You can get much nicer offices if you have two entities working in an office rather than one. You can have someone on your payroll part-time who would otherwise need a full-time job if you can split them between two entities. And essentially that's what's happening with these two-hat affiliates, is that they are using the money of the checkoff to make themselves look better without having to have all those resources. And certainly some in this world have called that corrupt. Technically what they're doing is they're creating a wall between the two entities, and they're, essentially what's happening is that the state council is just paying rent. And so, whether that actually is corrupt is a point of debate, but I actually think there's a lot that can be done at the legislative level to fix that. And this is something that I know I've talked about in prior conventions and we're looking at kind of both nationally and at state level. So both Cory Booker and Mike Lee, so the senator from New Jersey and the senator from Utah, have co-sponsored a bill that's now picked up other sponsors called the Off Act. And the details of the Off Act are a little bit complicated, but the main gist for Vaughn's point is that what it says is no checkoff money can go to an entity that engages in lobbying for a specific policy. And were the Off Act to pass at the federal level, or miniature Off Acts to pass at the state level, that would undo the two-hat problem as long as it was clear that money going to an entity that was engaged in lobbying included things like rent and stuff. And so I do think that as these cases have developed, as ARCAV has been working with other groups, this issue has gotten more and more attention. There certainly are people paying attention to it. I think legislative solutions are the best fix that are out there.
Dave, this is David Wright, and I've spoke with you before. That's an interesting concept that you have with the state beef councils, contracting that money out, in other words, to their ARs, to non-governmental. That is very interesting. I would like you to consider NCBA does the same thing on a national level. They're the contractor, and then they turn around, they subcontract out to particularly USMEF. Actually, they don't subcontract, they buy seats with those checkoff dollars at USMEF, but then they'll turn around and subcontract research to universities. So what they're doing is they're basically spreading the money around to keep consensus, so if this ever comes to a vote or any kind of a fight, you see they're lining up their allies because they're all getting a chunk of that money. And same when you were talking about the beef councils, one of those, usually those subcontractors are the state affiliates to NCBA, like Vaughn was talking about in the two-hat state. But it's not necessarily just two-hat state. We'll hire the state affiliate to do promotion, we'll hire the state affiliate to do something or another, So I think you're on the right track. I would like to know, I've asked before, and I'll say it again, if the act of Congress says that the producer has the right to leave up to 50 cents at a beef council, and that's the act of Congress, and it says it in the order also, but then as we know, when you guys started your lawsuit, they tried to reverse that and say we have to opt out as opposed to opt in. But the act is clear that we have to opt in if we want a beef council to have any money. Doesn't the act have more standing than the order does?
So two really good points. As the first point about spreading money around, I again will say that I think the Off Act is trying to get at that. We'll see the Off Act hasn't been kind of picked up by the full Senate, although it's gotten increasing numbers of sponsors. And so we want to make sure that people are paying attention to what that language looks like, because that spreading around, I think, is going to be, that's how you limit it, right? The idea there is, NCBA as a specific focus, is to say, if all this money is going to NCBA, an entity that engages in lobbying, something's wrong there, and we need to stop that. And I do think these statutory changes are really important and a viable way forward, and something that I know Bill's been doing a lot of advocacy around. On the second point, so you're raising a point that I know Dudley has raised with all of you before, and let me try to give you my best answer on this. I have not studied this as well as I should have, but so you're absolutely right. The way the statute's phrased is that it says that you have the right to make a voluntary contribution, that's the language in the Act, to your state beef councils. And what the government has consistently said, and now thanks to our lawsuits, has established a rule that says that you can opt out of giving money to the state beef council. So if any of you wanted to take the time and energy, and I realize the government's made it as cumbersome as possible, but if you want to take the time and energy, as of today, you could tell your state beef councils you don't want them to have your money, you want all the money to go to the federal government. That is what the government would argue there is that is a regulatory interpretation of what voluntary contribution means. That they are allowed to, that the word voluntary is ambiguous, and that they are allowed to interpret voluntary to mean opt-out. And historically, those interpretations have gotten a lot of deference. And the way this program has been set up for a really long time has allowed this to persist for decades. And so there are two questions that would have to be answered. One is that interpretation actually not entitled to deference? And two is, have we all waited too long to challenge that? Typically, there's a 6-year statute of limitations for challenging regulations. And as you all may recall, when we did litigation with you on Cool, right, that's one of the things that we ran up against, was not that the regulation itself made a lot of sense, but part of the problem was that the regulation has been around too long. And so you'd also have to think about whether we've exceeded those 6 years. And so those are the two questions on voluntary contribution. I agree with you that the language does not seem to suggest opt-out, but the question would be, have we waited too long, and is there too much deference?
Hi, Dave. My name's Nicole Frang. I'm from Kansas, and my question is, how would you suggest the government keep KLA to honor the MOUs when they didn't even know the Kansas Beef Council existed until my dad went into the state ag to sign and own the Kansas Beef Council?
Yeah, so this is Kansas is a really interesting version of this. So in Kansas, the Kansas Beef Council is not the Kansas Beef Council that gets your checkoff money. Let me phrase it that way. That gets your checkoff money, what's known as the Qualified State Beef Council, is not an actual entity. You can't, if you go on to the Kansas website, you cannot find at the Secretary of State website, you cannot find something that the entity that takes your money. It only exists as part of the Kansas Livestock Association. And the way its bylaws read are the president of the Kansas Livestock Association has to be the president of the Kansas Beef Council that gets your money, and the vice president, et cetera, et cetera. It's a really corrupt system. Not to sound like a broken record, but I think one answer here is legislation, right? The Kansas Livestock Association engages in lobbying. If your beef checkoff dollars can't go to an entity that engages in lobbying, you keep the Kansas Livestock Association can no longer take that money and use it, right? That's a legislation that hasn't passed yet, but that is one solution here. Another solution is that I will say that one of the things that our suit accomplished so far is that the Kansas Livestock Association the Kansas Beef Council that gets your money can only operate consistent with the MOUs. So if there was evidence that, I see you shrugging, I see the screen, so I'll let you talk in response in a second. If there's actual evidence that they are taking your money inconsistent with the MOUs, that's something we could go back to court on. But let me hear your follow-up, because I know there's a follow-up. So let me stop and let you talk.
But how are they supposed to follow it since it's KLA? KLA gets the money. Yeah, right to the Kansas Beef Council, but KLA owns the checking account. So how are they supposed to keep track of that? Because it all goes to KLA.
So the answer is this: they're supposed to keep track of it, right? I mean, this is what the government's job is. That under the MOUs, the government, USDA is supposed to get the audits of those entities and get the books. And if you think something's corrupt there, USDA has both the duty and right to go in and figure out what's going on. And we haven't actually looked at this, but one of the benefits of the USDA having to take all this information is we should be able to FOIA that on demand that it become public. That's not something that I personally specialize in, but that is something that I know other groups are looking at. But that's the answer: is that yes, they all go into one account. They are supposed to, and I fully share your skepticism. So don't hear me as saying that I'm believing that this occurs. I'm telling you what the law is asking of them is they are supposed to keep track of what money is coming in that goes to which entity and make sure that it's only spent on that entity's activities. And that is part of USDA's oversight obligations. I get the skepticism about that they are playing fast and loose, and that's one of the reasons I think legislation saying that they can't pool money like that makes a lot of sense. But that's the legal answer, is that this is now on USDA, and it's on you all to hold USDA and Joe Biden to hold Tom Vilsack accountable on this.
Just one more question. I asked this question a different way last year. Let's take it from a different angle. From your experience, what happens if none of us paid the damn checkoff?
So you're asking a lawyer to tell you something. You're gonna watch me squirm. What I will say to you is that the government requires you under the statute to pay the money.
I know that, and I don't want you as our lawyer to advise us to do anything unlawful.
Yeah.
I just want your opinion on what happens if nobody paid the damn checkoff.
The government, and so I think there's the question of like, what has historically happened, which is the government has not seemed to pay a lot of attention to who's paying. I will say that. My impression is that the government doesn't pay a lot of attention to whether the money is coming in or not, and doesn't have a very good record of who should be paying. I think that's all true. I will tell you that the government, my understanding is in those circumstances, could begin prosecutions through its administrative law offices, and you could get fined. I think those fines are pretty hefty if they actually were to occur. I'd have to look up what they actually are. I don't think it's a criminal offense, to be clear. I think it's civil and that's damages, but again, I'm not an expert in that. But, I'll tell you that no one seems to have been paying a lot of attention, minding the hen house on this one, if that's your question.
Frank Andrus from California. In our state, we have mandatory brand inspection, and they set it up so the brand inspector collects the checkoff money. And so it'd be difficult to not pay, although I do agree with Dr. Haynes there.
Well, and I do think that we've seen in other checkoffs, they have, to that point, they've developed systems that are designed to make sure the money gets paid. Who actually ends up paying that, I think, is an interesting question. So, in the pork system, the slaughterhouses, I believe, primarily pay. Right? Does that actually get passed along? I don't know. That's something that you all can answer in terms of how the dollar actually gets, or in pork, it's not a dollar, but how that money actually gets passed along. But there are other systems, as it becomes more vague, I think who's actually paying versus who's supposed to pay is a little bit less clear, for sure.
Dave, this is Dave Wright again. I'd like to follow up on Ms. Frang's comments or her questions. So we all know how KLA's work and Kansas Beef Council. It's the same thing with the Federation and NCBA. The Federation does not legally exist. There's only one CEO and one CFO. The Federation does not legally exist. It's not recorded. The IRS, they don't pay that. There's no 990. There's no IRS claims to the Federation. And Dave Domina pointed that out to me many, many years ago. So, and NCBA is obviously a lobbying organization, and they're receiving those checkoff dollars. So when they show that chart like you did at the beginning, where it shows how the money is dispersed, and it's very misleading to say the Federation collects that money, because that's like saying the Red Barn collects that money, or North 40 collects that money. It doesn't exist. It should say NCBA in bold letters. It shouldn't say Federation. It should say NCBA. It's a deliberate shift, sleight of hand is what it is.
Yeah, so I want to tease out two different things here, because I think you're all kind of honing in on two slightly different things. And I just want to make sure, as you think about the right way to respond to what's going on with these programs, you understand the difference. So one is that how your money is being spent. And at the committee level, the Beef Board and Beef Committee, USDA has always reviewed those expenditures. So you put in $20,000 that goes up to the Beef Board, it goes to the Federation. USDA has, since day one, looked at how that money is being spent. And you can all say it's a gigantic waste of money. I think it often is. You can all say that you're not getting $20,000 worth. I think that's perfectly reasonable. But that is a political expenditure. And the way to kind of hold those people accountable is through politics, to say, you're wasting our money. The other part is the accounting part, which is to say, well, when that money gets spent, it ends up transferring $20,000 to NCBA. And then they turn around and use that money for lobbying. And that's what the Off Act is getting at. And it's also, and this is a slightly different part of the politics. It's not about what the actual $20,000 was spent on, but who's spending it. And, in saying that USDA is not caring enough about who's spending it. And again, the Off Act is meant to get at some of that problem beyond just the actual expressions, which we can all kind of debate whether they're good or not. I know Vaughn's done a bunch of research to question whether they've actually produced enough value. I just, I think there's two slightly different things. We're kind of mesh them together. I just want to emphasize the distinction because I think they give you two different pressure points as you go up. It actually gives you more options to point out the corruption.